Welcome, everyone. I'm Rick Hagerstace from Canada's National Firearms Association, and I want to present to you today Canada's most well-known firearms lawyer, hands down, Solomon Friedman.
Hey, everybody. First of all, a little bit about myself. I've been doing firearms defense for almost 15 years now. It is unfortunately a growing segment of my practice, and it's a segment of my practice that I wish did not exist. And in fact, if we do our jobs on the legal, the political, the social front, then I will never practice in this area of law again, which is a success for me. Because invariably, when people come to me in trouble, regulatory, criminal trouble, they say, I never in a million years expected to need a criminal lawyer. I paid my taxes, I comply with the law. Like most of us, I go beyond the letter of the law, and what the hell am I doing in a criminal lawyer's office? And I say, that's the problem. The problem is that in Canada, we have no standalone regulatory scheme for firearms. Instead, we have the Criminal Code and the Firearms Act, where your first stop, unlike when you get pulled over, you park illegally, is a ticket and maybe a trip to Provincial Offences Act court. The first stop for firearms owners who inadvertently, who unknowingly or otherwise violate the Firearms Act is the police, the criminal courts, and in terrible cases, jail or the penitentiary. It's the way our system, unfortunately, is set up, and something that I know a number of organizations, and particularly the NFA, is working hard to change. I represent a woman named Cassandra Parker. Cassandra is a small business owner. She's a mom, she's a target shooter, she's a hunter, and like probably everybody in this room, she was devastated when on May the 1st, 2020, with no warning, no consultation, no legislation, no vote in Parliament, like that, with the snap of a finger, her firearms were prohibited. Her personal firearms were prohibited. Her business's inventory was prohibited. The inventory that they had paid for but had not yet arrived was prohibited. I mean, maybe I'm nuts, but that seems kind of unfair to me. She complied with the law, she got licenses, she got permits, she got a business license, she complied with the regulations, she kept her side of the bargain. And overnight, her property, along with many of ours, was prohibited. No recourse, no redress, no appeal, no committee hearings, the stroke of a pen by the governor and council. So, as a starting point, it seems kind of unfair, but stamping your feet in court or otherwise and saying that's unfair is not a legal argument. So what is the legal argument then? How were those firearms prohibited, and why do we strongly believe that that was illegitimate? And I say we because one of the most amazing things about challenging this order in council is that I was not alone and we were not alone. So Cassandra's matter was very, very generously funded by the NFA. Cases like this are not easy, and I'll talk about some of the obstacles and what we built in this case. Cassandra and I had the full, absolutely uncompromising support of the NFA every step of the way. So, first of all, how does our property just get reclassified overnight? How does that happen? What's the legal mechanism? So we live in Canada, so I'm told, where the rule of law is supreme. In other words, everybody has the right to be treated equally under the law. Is that true, by the way? Is that the general feeling in the room? And everyone has the right to challenge laws that they're dissatisfied with. No process can happen without legal authority. So what was the governor and council? Also, first of all, who the hell is governor and council? Does anyone know? In practice, what it means is cabinet. The federal cabinet is the, quote, governor and council, right? If you read our Constitution, you won't see reference to cabinet. You actually won't see reference to prime minister. It all is encompassed by that term governor and council. But it's the Prime Minister and Cabinet. Laws are made by Parliament. Parliament, however, in their lawmaking authority, can delegate their powers to the Cabinet. And they do that when it comes to the details, generally, of complex rulemaking, and that's called regulation. But every regulation, and here's an important one, every regulation must be authorized by a statute. And every regulation must do only the job that the statute lets it do. Because Parliament, of course, is supreme. You get to vote for Parliament. Parliamentarians, MPs vote for laws. So every regulation has to be authorized by Parliament in a statute somewhere, and every regulation has to respect the boundaries of that authorization. What's the authority for Cabinet to prohibit firearms? Well, it goes back in time to something you might have heard of called the Firearms Act, which, by the way, didn't exist until 1998 in Canada. The way I described it, it was supposed to be a deal, all right? Doesn't matter if it was a good deal or bad deal. It was supposed to be a deal. The deal was everybody get licenses, everybody register their firearms. That's the ask, which is a tall ask because prior to the Firearms Act, it wasn't a crime to own a firearm if you didn't do anything illegal with it. But there was this new approach that was going to make it a criminal offense to possess a firearm without a license, even without any legal activity whatsoever. So that's the ask. On the other side, as you can imagine, people were like, well, if you have this power to license, register, and classify, you're just going to classify all of our firearms to prohibit it. The government said, come on, conspiracy theorists. This is crazy. We don't want your guns. Don't worry about it. It's just a little license and registration. But there were some savvy people, there still are, among the firearms advocates, and they said, we need some protection baked into this. So the government said, all right, I'll tell you what. We'll put right there in the criminal code that no firearm can be prohibited if it's reasonable for hunting or sporting purposes in Canada. So that, a lot of words in there, reasonable, hunting and sporting. So by the way, it says hunting or sporting, it means they're different things. So it doesn't mean only reasonable for hunting, reasonable for sporting. And that was the Parliament's way of saying, don't worry about it. We'll put a limit, right? We'll handcuff ourselves that we cannot reclassify as prohibited firearms that are reasonable for hunting or sporting purposes in Canada. They added a little wiggle room in there. They added one extra line. They said, well, it'll be in the opinion of governor and council if it's reasonable for hunting or sporting purposes. But there was a limit. So that's the limitation on that power. No firearm in Canada can be prohibited if, in the opinion of the governor and council of cabinet, it's reasonable for hunting or sporting purposes in Canada. That's the source of the authority, and that's the limitation. Are AR-15 type rifles reasonable for hunting or sporting purposes in Canada? Hunting purposes, obviously they're restricted, right? That doesn't make them unreasonable, that just means the law says you can't hunt with them. They're perfectly reasonable, right? In fact, firearms of the same caliber, of similar action, exact same magazine capacity are used all the time for hunting. In fact, our wildlife and conservation officers are ordering AR-15 by the dozen for use in their work day in, day out. Which is funny because some political figure, I don't know who it is, his name escapes me, he said, who needs a AR-15 to hunt deer? Now, if he knew the first thing about guns, he'd know that the reason, not a matter of needing an AR-15, an AR-15 is not even powerful enough to ethically hunt deer in virtually every jurisdiction. But it's a single-purpose built machine for this same politician, who is, it won't be named, also said its only purpose is to kill as many people in as short time as possible. Which is funny, because you should tell that to the conservation officers, that the guns that they're ordering by the dozen and that our police officers are using, oh, by the way, I forgot. When police officers use AR-15s, they stop being assault rifles and they start being patrol carbines. So it's weird, huh? It's the same gun, the same ammo, the same color. In my safe, it's an assault rifle. In a patrol car, it's a patrol carbine. So Ms. Parker, along with many other applicants, had a absolutely legitimate challenge. The criminal code says you cannot prohibit firearms that are reasonable for hunting or sporting purpose, The only thing I use these guns for are hunting or sporting purposes. You would think that the government would have done an enormous amount of research to prove that these firearms were not reasonable for hunting or sporting purpose. But when we went to court, we asked the government, can you produce the basis of your opinion? The criminal code says you gotta form an opinion. So who did you ask? What did they say? Can we have the basis of the opinion? The government said no. Many of the applicants applied to the court for an order forcing the government to hand over the basis of their opinion. And the court, Her Honor, said, yeah, that's reasonable. You should get that disclosure. But they have to give you the reason for the decision. And we said, you made a decision here, we'd like the reason for it. So the judge said, I agree. Give them every document that you reviewed in arriving at the opinion that the criminal code requires you to arrive at. The day after Her Honor made that decision, we were served with a certificate from the Attorney General asserting cabinet confidence. So the amount of disclosure that we got from the government on that issue, zero. But what do I know? I'm just a lawyer who practices in this area of the law. As I said to one judge in the course of a different proceeding, I said, it's not like I wrote the book on this. Well, no, I did actually write the book on it, and if you have trouble sleeping at night and want to read the world's most boring book, I recommend, or need a doorstop, I recommend the annotated Firearms Act. So when they say these aren't hunting rifles, first of all, they're wrong, but second of all, it's irrelevant because sporting purposes is captured separately. And sporting purposes has been held to have a different meaning than hunting. First of all, these guns are reasonable for hunting or sporting purposes, so you couldn't have formed such an opinion. So what did we do? The government wouldn't give us any disclosure, so we did what sensible folks would do, which is we found experts on these guns. You know, nothing was more satisfying to me. So for example, one of the firearms that's included on the order in council, obviously there's all the AR-15s, and I think they banned a few brands of coffee too while they were at it. But once they got their list straight, stopped banning toys and coffee, they banned the Robinson arms. Resemblances to the AR-15 model, but totally different, okay? So we thought, you tell us the Robinson arms is not suitable for hunting or sporting purposes. So we went to a gentleman named Alex Robinson, who invented the Robinson arms, who built it from the ground up. And we had him provide evidence. And he said, I designed this exclusively for hunting or sporting purposes. There is no military or police user of my rifle anywhere in the world. And in fact, I made a whole bunch of design decisions to make it better for hunting or sporting that would be inappropriate in a military or law enforcement context. I'm the guy who built this rifle. So how can you say it's not reasonable for hunting or sporting purposes? Let me explain every design decision I made. Do you know how long the government lawyers spent cross-examining him, rebutting his affidavit? Zero. Asked no questions. So, those were the quality of the affiants who we put forward. And we put forward a wide range of affiants. So for example, we were very lucky to have the head of the DCRA, the Dominion of Canada Rifle Association. What is the most popular rifle in the DCRA's service rifle category? The AR-15. In fact, the reason why today AR-15s were only restricted was because of the work of the DCRA and others to explain, hey, we shoot service rifle competition with this all the time. So we bring this, we call it a record to court. And the record, and the NFA was extraordinarily generous in assisting with this. Our record that we filed on behalf of Ms. Parker was 6,700 pages long. So that's 6,700 pages of evidence, of transcript, and of legal and factual argument. And this hearing took 2 weeks. I was the first to speak. I was a privilege to do that, and I offered a challenge to the Attorney General. I said, I want you to ask them, in the opinion of Governor and Council, what firearms are reasonable for hunting or sporting purposes. Firearms that are reasonable for hunting or sporting purposes can't be prohibited. So, Attorney General, can I have a list? So in other words, I was asking the question, what firearms can the Cabinet not prohibit by regulation? When regulations are passed, there is no vote. Zero vote. We don't even get to know about the vote that happened in Cabinet because of Cabinet confidence. There's no vote, there's no accountability, there's no committee hearing, no first, second, third reading, House of Commons, no first, second, third reading in the Senate. Their answer was, well, and I want you to listen to this because this is a true story, and the hearing was live streamed, so it's all available. They said, okay, the law requires the Governor and Council to form an opinion that the firearms are reasonable or unreasonable for hunting or sporting purpose. All the Governor and Council has to do is form an opinion. That's it. And they instantly become unreasonable for hunting or sporting purposes. According to the government, all Cabinet has to do is form an opinion. It doesn't have to be a good opinion, bad opinion, right opinion, wrong opinion, any evidence, any data whatsoever. Which means that essentially that limit in the criminal code is no limit at all. That means that bargain that we made is no bargain at all. That cannot be the law. And that's what we argue. There's a fun term in Latin, and it's one we focused on in this hearing, and that term is UltraVZ. UltraVZ means beyond the power. This regulation is UltraVZ Cabinet. It's beyond their authority because they did not comply with the criminal code. So that was one plank. The second plank was that the Charter of Rights and Freedoms in Section 7, we are guaranteed life, liberty, and security of the person. So liberty means not going to jail. And we're guaranteed those rights except in accordance with the principles of fundamental justice. What are the principles of fundamental justice? So there's a whole bunch of them. One of them is that laws cannot be arbitrary, vague, or overbroad. I'll give you a vague term. It's a really important term. The Order in Council prohibits AR-15s, among other families of firearms, and their variants. What are variants? There's an airsoft booth over there. Is that airsoft rifle a variant of an AR-15 that looks a hell of a lot like an AR-15? We did a little bit of research. It's what you do when you're trying to be serious about a legal problem. And we got access to information requests from the firearms lab at the RCMP. Okay. That would be a good place to start. They decide what variants are, by the way. So what's a variant? We tendered this in evidence. An email from a firearm technologist. A good soul, I gotta say, writing internally, who said, we are tasked with determining what's a variant of a prohibited firearm. We have no criteria to do it. We have no definition. He wrote, there's no definition of variant in the law. The decisions we're making are often contradictory. So for example, he gave an example, this shotgun we said isn't a variant, this shotgun is a variant. The one that isn't a variant is more similar to the one, to the original than the one that we deemed to be a variant. He said, it seems to me that the question of what is and is not a variant is nothing more than a lottery. And I said to the judge, citing this email, yeah, it is a lottery. And the prize is you're going to jail. Do you know what the government said in their consultations as to why they don't want to define variant? It was recommended, by the way. Their expert panel, their own expert panel, recommended define variant. They said, if we define variant, then firearms businesses will just find ways to get around it, so we're not going to give a definition. Like, this is real life. So we argued that the law is vague. And the reason why can't we have vague laws? It's not just because I'm a stickler for good laws. And it's weird, I'm going to blow your mind with this concept. In a free society, people should know when they're breaking the law or not. Weird, eh? You should be on notice that today you're not a criminal, but if you do this tomorrow, you are a criminal. Laws can't be vague. You should always be entitled to know if you are complying with the law. We also said laws should not be arbitrary, and that's guaranteed by the Charter of Rights and Freedoms. This one sure strikes me as arbitrary. I remember in that presentation, we put up something, and I'm sure you have spoken about this to your friends and your neighbors and your colleagues. We put up an SKS. Now, it was one of those fun SKSs where people with more money than sense have spent time dressing it up in all kinds of plastic with a long-looking magazine. You know what? I shouldn't say that. I don't hate on anyone's personal firearms choices. You do you. You let that freak flag fly with your SKS. So we put that up on the screen. SKS is chambered in 7.62 by 39. SKS is Soviet design. Designed in what year? NFA will give away a prize, whoever gets this right. 1945. Put that up on the screen, okay? Simonov, SKS, okay? 1945. We put up on the screen another gun, and I want you to hold on to your chairs because it's a scary gun, okay? And this gun is a AK-47. AK-47 is a gas-operated system, a little different than the SKS, different mechanism, different piston assembly, different bolt. One is non-restricted, for now. We'll get back to that. Non-restricted, take it hunting, take it to the gravel pit. When it's being transported, or being stored, or being displayed, it's subject to the regulations governing non-restricted firearms. No need for a lock when transporting. Need only for a lock when storing. Non-restricted firearm. What about the AK-47? And I know it's a scary one. AK-47 is prohibited until the case of Noor, and I'll give an enormous shout out to the NFA because I actually represented the NFA at the Supreme Court of Canada when this was struck down. There was a mandatory minimum 3-year sentence for possession of a prohibited firearm with accessible ammunition. So the SKS, there's no minimum. They struck that down, and I remember getting a lot of questions, and the NFA got a lot of questions saying, what are you guys doing up at the Supreme Court talking about no mandatory minimums? Isn't that just for gangsters, gangbangers, and criminals? They're the ones with guns stuffed in their jeans, prohibited firearms. Law-abiding firearms owners don't need that. Well, guess what all of you have at home in your safe today? What do you all have with your AR-15s now? You all have prohibited firearms. And if you have readily accessible ammunition, you make a mistake, you forget to lock something up, mistakes happen. That 3-year mandatory minimum that the NFA worked to overturn, and the reason it was overturned was not to protect criminals. In fact, the court said, look, we're giving those gangbangers 3 years no matter what. We don't need a mandatory minimum sentence. But innocent people can be caught up in this, and that, the Supreme Court said, would shock the conscience of Canadians. We're striking this law down. Don't worry, we'll still keep giving the gangsters the 3-year plus sentences. So that AK-47 is prohibited. That SKS is non-restricted. To me, that sounds a little arbitrary. So we put forward that argument. We put forward, I think, a compelling case that this law is unconstitutional. It violates Section 7 of the Charter. It is also just straight unlawful, not authorized by the Criminal Code. Where are we now? And where do we go from here? As was expected, the judge reserved her decision. That means she did not give an immediate ruling. She was presented with tens of thousands of pages of documents, it makes sense. 2 weeks of oral argument. Actually, I'll give one more shout out in this case because it was fabulous. Do you know who intervened on the side of firearms owners? Alberta's Chief Firearms Office. So a huge shout out, Dr. Terry Bryant, the Chief Firearms Officer of Alberta, an extraordinary person. Her office was there. They intervened. They made some really great arguments. Oh, by the way, who wasn't allowed to intervene? Whose application to intervene was denied? We're not going to mention them. But they were not allowed. You know what the judge said? The government is the gun control people. We don't need the gun control people intervening twice. How many kicks of the can did they have? Oh, by the way, this was fun. I'm sitting there on my side of the courtroom with amazing advocates, administrative law specialists, experts on our side of the courtroom. 9 government lawyers sitting there full time. We've made our arguments. The judge has reserved. There is no due date. That's one of the cool things about being a judge, by the way. You make the due date. It's a good job. So we're looking forward, obviously, to getting that decision. We don't know when it's coming. Ideally, we need it before the law comes into effect and the amnesty expires. If that doesn't happen, all the parties have got their eye on the ball. We're going to bring an injunction application. And exactly like happened the last time, at the very last minute of our injunction application, the government will extend the amnesty. It's funny how they do that, right? Like make us spend hundreds of hours, tens of thousands of dollars, and then, oh, just kidding, have an amnesty for another year. So we've got an eye on that ball. I have said a number of times in a number of different forums that we will never win in the courts. Okay? Litigation, as a way of affecting public policy, is like the difference between battlefield surgery on one hand and eating healthy, getting enough exercise, staying in shape, going to your doctor all the time, etc. One is to stop the bleeding in emergency situations. That is the best we can ever expect from the court. Because if we're in court, it means we've already lost 90% of the battle. We're now trying to do something extraordinary and overturn a bad law. That doesn't mean we shouldn't go to court. We do go to court. We need to fight. We need to make these arguments because, in my view, they are the right arguments. But we don't affect public policy through the courts. We know, of course, these laws are made in Parliament. We know that MPs are elected. Politics are incredibly important. Okay? But not at simply the level of electing one party over another, because there are parties who will make lots of promises and do very different things once they get into power. And I'll give you an example. We know, for example, the long gun registry was abolished by the Conservatives. That was kind of the beginning of my gun law journey. I spoke in Parliament a number of times. But in general, gun control is like a ratchet. It only moves one way, and that was extraordinary to see it moving the other way. So it can happen. It's hard to do it. And that's the reason why Parliament passes these laws, because they know it'll be hard for another party to undo it, even though all it takes is a simple majority in Parliament. So change starts at a much more basic level, in my view. Change starts, it's funny, you know, we have the NFA does incredible work. We have other organizations doing amazing advocacy work. But to me, the meat and potatoes of firearms advocacy actually has nothing to do with those organizations. It has to do with individuals, speaking to other individuals, demystifying guns, taking friends to the range, taking neighbors to the range, discussing firearms. And it can be a scary thing to do, right? Because there's a lot of judgment out there. We have on our side an actual positive experience, a legal, safe, responsible, pro-social experience. And do you know how much firearms contribute to the Canadian economy? The number's in the billions. Do you know how much the anti-gun contributes to the Canadian economy? Well, you need a negative and a big red number. So that's where it starts. It starts with making relationships, with being an advocate on an individual level. You don't have to work or volunteer for a firearms association in order to be an advocate. You should absolutely support them. If you are a firearms owner and you are not a member of at least one, if not more, why not more? Ammo is expensive. For the price of a box of ammunition, now I bought in bulk a long time ago and I'm still working on my supply, but I see the prices and they scare the living heck out of me. You need to donate to these organizations and you need to support them. And they're here. I know the NFA backed us. We got amazing support, but there are a number of organizations, and I'll be very honest with you, to me there's no competition when it comes to firearms advocacy. Everybody brings their own perspective to the table, they bring their own approach and their own relationships. There is no room for jealousy or competitiveness, and something that this challenge has brought home, and it's been wonderful to see. It's a real change, by the way, I'd say over the past 2 or 3 years. That is a spirit of cooperation among our organizations. Everybody taking their own flavor, their own style, that's fine, but it's, to me, insane that there are 2 million licensed gun owners and the number of members of these organizations are counted in the tens and hundreds of thousands and not the millions. We need them. Back in the 90s, the philosophy when it came to the Firearms Act was divide and conquer. It was, we're just going to go after the full auto guys, 1968. Don't worry about it. You're not, and we're like, oh, we're not full auto. Don't worry. Okay, let them go. Goodbye. And by the way, when we give up the full auto guys, then the crowd will be satisfied. They just want full auto. And you're like, yeah, full auto, fair enough. I'm not a full auto guy. I'm too young, I'm jealous, right? Okay, then converted auto. Well, you said it was just going to be full auto. I guess there aren't that many in converted auto. It sounds scary. It has the word auto in it. All right, you can have them too. Then it started going to named firearms. The FAL, the AKs. Well, those aren't my kind of guns, and those guys, you know, I can't own them. Okay, but you promise you'll stop, right? You promise. Oh, yeah, okay, I promise. Okay, we're going to prohibit the AR-15. We're going to prohibit all semi-autos. We're going to prohibit all handguns. But you promised that you were going to stop, right? Like, isn't that what you said you were going to do? So that's divide and conquer. And it worked on us, by the way. We bought it as a community. I'm not saying everybody's individually responsible, but we bought it. And we thought that if we give this up, they'll leave us alone. Something that to me, and I'll give a shout out to any organization doing great work, was the Ontario Federation of Anglers and Hunters. They commissioned an extraordinary report that we used in this court challenge, and they opposed the reclassification of the AR-15 and all of the Order in Council. That was a group that wasn't singing that tune 20 years ago. But they realize now your bolt-action deer rifle is a high-powered sniper rifle. Your pump-action shotgun is a tactical killing machine. By the way, it's so funny. Does anyone have any low-powered rifles? Because I read a lot about high-powered rifles, and it's funny, like, if I was to come up with the definition of a low-powered rifle, what would I say? I'd say the gun would be light, the round would be light, it would be relatively low power, it would have low recoil. That's a low-powered rifle. I'm trying to think of that, an example of one of those. Oh, that's right, it would literally be the AR-15, a firearm most suitable for gopher, maybe coyote, and smaller. But these are high-powered rifles. They're designed to kill as many people in the shortest amount of time possible. News to me. That divide and conquer game has to end, and we have to stand up for it. If you don't own an AR-15 or you don't own a handgun, it's irrelevant, because they're coming for whatever's next. Have you ever heard of something called Bill C-21? That sought to ban every single semi-automatic magazine-fed rifle in the country. That's exactly what they tried to do. And it failed because, as it turns out, even the majority of the non-gun owning public know it's nonsense. Oh, we want to hear another funny coincidence? When did they bring these amendments forward? Oh, that's right, it was literally in the middle of our litigation, because that would have ended it if Parliament had passed those laws. But the committee refused. They couldn't get it through the majority of the committee. By the way, this is not a majority Conservative committee. This is a committee in which the Liberals and the NDP held a majority when taken together. Couldn't get it through that committee. Said to the judge, there's a reason they did it by regulation, because they could not do it democratically. So they're coming for everything. So the question then is, where do we go from here? C-21 is not law yet. Although it's funny. You want to hear a cool magic trick? C-21 says you can't transfer restricted firearms between individuals. In other words, handguns are banned. There's no two ways about it, right? Like, imagine if you had a golf course with a big sign that said no new members. That's the end of the golf course. So it's weird. That's in C-21. Has anyone tried buying a handgun recently? C-21 is not law yet. Has anyone tried buying one recently? Or transferring it to a private party? You can't. Oh, that's because of a magical regulation to do that with basically the stroke of a pen. We don't need things like parliament and democracy. They're so inconvenient. You know, it's almost as if we have a political leadership that admires the basic dictator structure of some other countries because they're so efficient. But no politician would ever be foolish enough to say that in public, right? Like, it's absurd. So we have the effects of C21, but C21 hasn't yet done what it's supposed to do. We've got hearings, we've got ways to go. This is a precarious time, frankly, and it's one where the advocacy organizations need our support. It's one where politicians need to hear from you. And I'll tell you, don't make a mistake of thinking that if someone's from a particular party, it's useless talking to them, either because you think they already agree with you or already disagree. Be polite, be respectful, be compelling. In fact, at the committee, I had long, detailed conversations with members of all parties. I'll talk to anyone who'll listen to me. And we obviously changed some minds because they couldn't get the AR-15 ban through the committee. They just couldn't do it. So you got to keep the pressure on. It's a democracy, and we have expectations of those who are elected to represent us. And obviously, it should go without saying, the next election will be the most important election for firearms owners, period. The only reason why C21 hasn't passed and far, far worse versions of it haven't passed is because it's a minority parliament. Like, the mask has slipped, right? We're no longer in conspiracy theory, like they do on everything. So, but that doesn't happen in the courts. Courts are battlefield surgery. The political process, the social process is far, far more important. And that's a job that lawyers can't do on their own, lobbyists can't do on their own. That happens at the grassroots level. But the best outcome is that the ban is overturned. In other words, if it's found to be ultra-vires, it is of no force and effect. That is, it's quashed, essentially. Now, Governor and Council could try again, obviously, maybe bring some evidence this time, maybe narrow the scope, but if an ultra-vires challenge is successful, the law is of no force and effect. It's just as if it doesn't exist. So that is our ideal outcome. You asked me how you take this back, and the answer is you need to influence the wider culture, right? One of the things that we've seen is enormous growth in the community as we destigmatize this, as we normalize it, right? The more you hide it and the more you're ashamed of it, the more other people are going to be scared of it. You know, like I said, I learned to shoot. I was in my first year of law school, and look, I was a 21-year-old law student. I barely knew that you could own guns legally in Canada. Like, I just didn't know. You have to normalize it, and then that builds the political influence. But there's no question that the law is in major, major need of reform. We got to make that happen. Okay, thank you very, very much for all your time and energy. I appreciate it. Enjoy the rest of Taccom.
Lovely to be here.